Masechet Ketubot Daf Chaf Aleph. We begin with a new Mishnah, more about ratification of signatures on a document. We're going to see a very interesting machloket about whether the signers themselves, when they come to ratify their document, are they confirming their signature or are they confirming the contents of the document? And that makes a difference in how many witnesses we'll need. The Mishnah says, Ze omer ketav yadi v'ze ketav yado shel chaveri. V'ze omer ze ketav yadi v'ze ketav yado shel chaveri. So we have a contract that was written some time ago, and now it's being brought to the court to apply it, and the court has to ratify the signatures. And we are lucky enough to have the two signatories here live in the court. And so they testify about two things. Witness A says, this is my signature, and I also recognize the signature of my friend B. And B also testifies, this is my signature, and I also recognize the signature of my friend A. I've seen his signature before, I know him for a while, and this is the same one. Hare elu ne'emanin, they are believed. Good, so in this case we have two witnesses on each of the signatures. Now, Ze omer ze ketav yadi, v'ze omer ze ketav yadi, tzarichin lesaref imahen acher divrei Rabbi. However, if each witness only testifies about their own, A says, this is mine, B says, this is mine, in that case, each signature has only one witness testifying that it is indeed an authentic signature. And therefore, they're going to have to find someone else who also knows them. So get someone else from the marketplace that says, yo, I recognize A. It could be the same person that knows A and B, or another person for A, another person for B. All that is the opinion of Rabbi Yehuda Nasi. Chachamim omerim enam serichim lesaref imahem acher ela ne'eman adam lomar ze ketav yadi. Chachamim, however, are more lenient, at least in this case, and they say no, they don't have to bring anybody else. If you have A testifying about his own signature and B testifying about his own signature, then we believe them. A person is believed to say, this is my own handwriting. Only if you're testifying about someone else's signature, then you need two witnesses about someone else's. So Chachamim are more lenient. What is the essence of their debate? Kishetimsi lomar. When you look into it, you'll find as follows. Al ketav yadan hem me'idin. L'divrei chachamim al maneh shebishtar hem me'idim. According to the B, the first opinion in the Mishnah, the witnesses are testifying about their signatures, and therefore, just like two other people, you need two to verify a signature. So too, even the signatories themselves are testifying not about the content of what's in the contract, but rather about the signature. And therefore, if they're there, that's great. But you still need one other person. They can talk about each other, A about B and B about A, as well as their own, or it could be someone else. But no matter what, you're going to need two because they're talking about the signature. However, according to Chachamim, if you have the signatories there themselves, then they are actually testifying about the contents of the document. If it's, for example, a loan document that says this person owes that person 100 dinar, so that's what they're testifying. And that's the reason why, if the signatories are actually here, we only need them two, them themselves. Even if A just says, I signed this, and B says, I signed this, what they're saying is that I am testifying that, yes, I signed this, and it says in here that he owes $100. And therefore, we have two witnesses on the contents. I don't need two witnesses on each of the signatures. Okay, good. Now we ask, Pishita, isn't this explanation obvious? Like, what else might I have thought? Isn't it obvious that, according to the Yehuda Nasi, you need two for each because they're authenticating the signatures themselves? So here's the reason why we have to say it, Ma'udetema. לרבי ספוקי מספק עליה אי על כתב ידם הם מעידים או על מנה שבשטר הם מעידים. I might have thought that Rabbi is actually unsure. He has a doubt about which way it is, about whether the signatories are testifying on their signature or about the contents, the $100 in the contract. And so what would be the difference if we're uncertain versus certain? Well, in this case, in the case of the Mishnah, Rabbi Yehuda Nasi is more stringent. But we're now going to concoct a case where Rabbi Yehuda Nasi would be more lenient. So if he's sure about his opinion, then he'll be sure about it for stringency and for leniency. If he's unsure about his opinion, then he'll say, you know what, we have to be stringent in both cases. So here's the case where we're going to test it out. V'nafka mina, the practical difference between whether Rabbi Yehuda Nasi is sure or not sure would be hecha demit chad minayhu, one of the original signatories, the original witnesses, has died, and so we only have one here. Liba'eh shenayim min hashuk leha'id alav. If I say, forget that line a second. So if I say that it's based on certainty, that Rabbi Yehuda Nasi is certain that we need signatories on both of, we need witnesses for the signatures themselves, then it would be sufficient to just have one other person. It would work as follows. We have one of the original signatories alive, A. He testifies about his own signature and about that of his friend B. Good. So now we have one signature, one witness for each signature. If we get one other person who knows both A and B's signatures, then he will testify also. And then we have two witnesses for A, the signatory himself, and this other guy, and B also. We have A and this other guy. And that would be sufficient. That would be the kula position if Rabbi Yehuda Nasi was sure about it. But if he was unsure and we focus on the content, well then we would need liba'eh shenai min hashuk la'id alav. We would need two other people from the street to testify about the other signature. The reason would be because A now is testifying about the content of the his side, right, of the content of the contract that he owes $100. So he's done. Now, if he's going to be also a witness to the signature, then you're going to have a problem. Because if so, then we're going to have the entire sum less a quarter is going to be based on one witness as follows. A testifies about the content. And this is again now if we think that Rabbi Yehuda Nasi is unsure, and maybe we have to worry that they're testifying about the content, like Chachamim. This would be the law according to Chachamim, that A is testifying about the content. Good. So he testifies about the content. He's one witness to the content. Now the other witness is dead, so he's not around to be able to testify. So instead, we have to authenticate his testimony by authenticating his signature. So now, how are we going to authenticate his signature? If we have only one other person, we have A and one other person. So A now is doing 3/4 of the work. And this is not good, because Torah says you can only uphold a legal matter based on two witnesses, and that further means that each witness is equally responsible, and not 3/4 and 1/4. And so that, therefore, if we said it's about the content, it's no good. So, now, if Rabbi Yehuda Nasi was unsure, then he would be stringent both ways. In our Mishnah, when both of them are here, we need them to testify about their own and about the others. A about A and B about B and A. And in our case, when one of them died, if Rabbi Yehuda was not sure, then he would have to be stringent to assume that we're talking about the content, and A could testify about the content, and B would require two other people to be signatories. So that's what I might have thought if I didn't tell you the reason for Rabbi Yehuda Nasi. And therefore I'm telling you that Rabbi Yehuda Nasi thinks that we are testifying only about the signatures, not about the content, and he would uphold that decision both for stringency and also for leniency. Good. And how do we know that Rabbi would say this lenient opinion? Rav gives exactly this case. You had two signatories, one of them died. According to the Rabbanan, we need two other witnesses, so that the two other witnesses will bear half of the testimony, and A, who's still alive, will bear half the testimony. Good. And Rav added that Rabbi Yehuda Nasi is lenient in this case, and he says it's okay for A to testify about his own signature. And then he'll go and testify about the other guy's signature as well, because he's simply testifying about one of each. And then you'll have one other person that is also testifying about the both signatures. And so that's equal sharing. And that's fine, because the reason it's equal sharing is because A is testifying only about the signature and together with the other guy, and not solely about the content. Oh, good. Okay, now we ask, according to Rabbanan, what if you don't have two other people? Is there a way to get around that? In other words, we have A, and B is dead, and we have someone else, one other person that recognizes B's signature. What can we do? אמר אביי, לכתוב חתימת ידי החספה ושדי לה בבדינה ומחזיקי לה בדינה וחזו לה ולא צריך איהו לסודע חתימת ידי ואז אליהו והי ומסדה האידך. Here's what you do. A, instead of using up all of his testimony power, because he can't use more than 50%, instead of using it all up on his own signature, what he'll do is he'll write his signature on a piece of earthenware, a broken piece of pottery. So he writes his signature in front of the Bet Din, and he hands it to the Bet Din. So the Bet Din now will independently verify A's signature on the document by comparing it with the signature he just made on the earthenware shard. And so now the Bet Din is independently testifying about that the A's signature is correct. Good, so that's done. And now, so we don't need him. We don't need A to testify about his own signature. Instead, he will use his power to testify about B's signature. And then B has one other person. And so with just A and one other person, there is a way to get around it, right? After all, according to Rabbanan, also, if the signatory is not around, then to testify about the content, then you can always uphold it with two witnesses on a signature. And so we'll use A for B's signature, and A's content, we're not going to verify directly from A, but rather we're going to verify A's signature with his earthenware shard signature. Okay, brilliant. Now, v'davka achaspa. Notice when Abaye said you should write on earthenware shard, that's what you should use. Ava megilta lo, but don't take a piece of parchment and write your sample signature on that. Because maybe someone who's not so upstanding may find an empty page with your signature on it, and they'll take advantage. He could write anything on it that he wants. Above your signature, he could write, oh, this guy A, he owes me $1 million. And that will be usable in a court. Because we have a Mishnah, Baba Batra, that teaches Utnan, Hotzi alav ketav yado shehu, chayav lo goveh min nechasim b'nei chorin. If someone produces a document that has a person's signature on it, and it says that person owes money, then that is usable, and one can collect with that from unsold property. So if you want to collect from property that's already been sold, then you need two witnesses on the document. That would be like that person has a lien on the property, like a bank today has a lien on a mortgage. If I sell my house that has a mortgage on it, and then don't pay the mortgage, the bank can go to the person I sold it to and say, hey, we had a lien on it. So same thing here. The lender could collect, if there's a document with two signatures, they could collect from even sold property. But if there's no witnesses, okay, they can't sell signatures. If there's no signatures, they can't collect from sold property, but he could still come and take one's property that he still has. So, and therefore it's not a good idea to write it unless you write it on a very small piece of parchment or on the top of the page. But if you use earthenware, that earthenware is not valid for a document of this kind, and therefore just write it on earthenware. Good. Amar Rav Yehuda, Amar Shemuel, halacha kedivrei chachamim. Shemuel now teaches us that the law is, according to Chachamim, that the witnesses that the signatory himself is testifying about the content, and therefore, if they're both here, A just testifies about himself, and B about himself, and they don't need anybody else. So we ask, Bishita Yachid v'Rabim halacha k'Rabim. Isn't that obvious? We're always going to go by the majority, and the other opinion was a Biuda Nasi. He's a minority. Why do you have to even tell us this, Shemuel? I might have thought that there's a rule that when there's a machloket between Rabbi and his colleagues, so the rule is that we follow Rabbi over any of his colleagues individually. That's a good rule. I might have thought that even Rabbi against multiple of his colleagues, even if he's the minority. So the first one is, if let's say there's 5 different opinions, none of them agree with each other, and one of them is Rabbi, yeah, we're going to follow Rabbi over any other single person. But I might have thought that the Biuda Nasi is so great because he's the Nasi, he's the final author of the Mishnah. So maybe he would trump even a majority. So therefore, Shemuel says, no, even the Biuda Nasi does not. We follow the majority. All right, good. More about this case, we're going to see an example that quoted by the following sages whose names are confusing. So we have mnemonic for them, Nach, Nad, Had. Okay, there's nothing related to Nachman, but rather it's talking about the names of the sages we're about to quote. So Nach stands for Rav Chinena Bar Chiya, Nad stands for Huna Bar Yehuda, and Chad stands for Rav Chiya Bar Yehuda. Okay, so here's how it goes. Amar le Rav Chinena Bar Chiya Rav Yehuda. Some say that Rav Chinena told Rav Yehuda. Amri Rav Yehuna Bar Yehuda le Rav Yehuda. Some say Rav Huna, his son, told it to him. Amri Rav Chiya Bar Yehuda le Rav Yehuda. And some say no, it was Rav Chiya, the son of Rav Yehuda, told us to Rav Yehuda. Okay, anyway, someone said this to Rav Yehuda. Rav Yehuda was the one that just quoted Shemuel. And the question is, Umish Amar Shemuel Hachi, did Shemuel really say the halacha follows the majority, the rabbis, that they're testifying about the content? We know of an actual case where a case came before Shemuel, that's the same Shemuel, and there was a document there that Shemuel dealt with. Vakativ be, and on this document was written, now this is not the original document himself that Shemuel was dealing with, but rather a ratification document. When the Bet Din comes and gets a contract and they check it out and they ratify it, they'll write a letter saying that we looked at this document and here's the witnesses and they said it's valid. That way you don't have to do the whole process again. Should you ever need it again, you could just bring the kind of like a receipt, a ratification document. So here's what it said. Mid'ata Rav Anan bar Chiya v'ased chatimot yedeh ve'ad echad de'imeh umano Rav Chanan bar Rava. In this ratification document it said, Rav Anan bar Chiya came and he testified about his own signature. And he also testified about the signature of the other person he was with, and that other person is Rav Chanan bar Rava. And the opposite also. Rav Chanan bar Rava, the other guy, he also came and testified about his own signature. And also about his colleague who was with him, and that is Rav Anan bar Chiya. That's the first guy. Asharoni v'kiyamnohi kedachazeh. And therefore, since we have both of their testimonies, we ratify the document as in the proper way. Now, this is a question, because you see here, Shemuel required that A and B both testify about their own signature and about their colleague's signature. Who requires that? The Biuda Nasi. So why did Shemuel require that? It looks like he follows the B, and this contradicts Rav Yehuda, what you just said, because you said that he says halacha is like Rabbanan. Rabbanan would only require that A testify about himself and B testify about himself. Okay, Amar le. So the answer Rav Yehuda has said is that document was on behalf of orphans, and therefore Shemuel wanted to go an extra mile just in case this one day will get into the hands of a Bet Din who that's not such a good Bet Din, who erroneously thinks that halacha is like Rabbi. And so he wanted to cover all the bases. There might be a betin that's somewhere along the line that thinks that, even if in general halacha follows to be only against a single colleague but not against a majority, but maybe in this case they'll think, I guess there was some tradition, there's some rumors about that, there's some people that think that, and maybe some betin will mistakenly think that we follow the Yehuda Nasi in this case against the majority. So you know what? I'll write it in an expansive manner. Happens to be true that we had A and B both testifying about themselves and each other. So we have that extra level. So I may as well write it that way to protect the orphans. If it wasn't an orphan, then he wouldn't bother doing it because then it's an adult. If it's an adult, then the Bet Din makes a mistake. The adult could say, "Hey, Bet Din, you don't know what you're talking about," and he'll write a letter and he'll figure it out. But for orphans, he wants to make sure that they have an easy time. So he writes it in a stringent way. All right. Amar Rav Yehuda Amar Shemuel. Since we quoted Rav Yehuda in the name of Shemuel, about one halacha, here's his statement about a related halacha, where it says, Ayed v'dayan mitztarfin. You can have a case where a witness and a judge can join together to certify a document. What kind of case would this be? Let's say there was a contract and it went to a court and the court wrote a receipt, a ratification document. And so later on, one of the litigants wants to use this document in court. And then the other party says, I don't believe it. I think the document is forged. And I also think the ratification document is also forged. And so he's denying that this ratification document was really written by the judges. That they in fact signed it. Usually the three judges have to sign the document. So he's denying not only the original document, but even the ratification document. So now we need witnesses to come and verify. So if you had the two witnesses on the original contract, so you re-ratify it, that's fine. If you had the judges around and the judges testify, yes, we signed this ratification document, then also that would be fine. Rav Yehuda Shemuel's chidush is I can have one and one. I can have one of the original signatories on the contract, as this is my signature, and I can have one of the judges who says, I signed the ratification document, and we can combine them together. Okay. Amar Rabbi Rami bar Chama. Kama ma'alya hashema'ata. Rami bar Chama says, Chazaku Baruch, what a fantastic chidush. I love that. Amar Rava, my malyuta. Rava says, what's so great about it? It doesn't even make sense. Mai de kamased sahada la kamased dayana. Mai de kamased dayana la kamased sahada. What the content of the testimony of the witness is not the same as that of the judge, and one of the judges is not the same of the witness. We have one witness that the contract is good, and one witness that the ratification document is good. But those don't match up. They're testifying about two completely different things, so it does not match up. So this is not a good halacha. Laki atar Rami bar Yechezkel amar al tesitinhu lehani kelale techayil Yehuda achi mishmeh tishmuel. So when Rami bar Yechezkel, Rami was Rav Yehuda bar Yechezkel's brother, and when he came around, he said, do not listen to the principles that Yehuda, my brother, said in the name of Shemuel. This is not correct. In fact, Shemuel did not say such a thing. Because you cannot combine testimony about two different things. All right, we have a replay of the same conversation in a different generation. Ikla Rabbenai achud Rabbi Chia bar Abba lemizban shum shemeh v'amar hachi amar Shemuel. One time Rav Nai, the brother of Rabbi Chia bar Abba, came and he was selling sesame seeds, and he quoted Shemuel saying, Ayed v'dayan mistarfin. I don't know why it's important that he was selling sesame seeds, but that happened to be then. And he says this halacha that Rav Yehuda just quoted. Amar Amemar kama malya hashemata shemata. Amemar said, what a beautiful chidush. Very good, I agree. Amar le Rav Asher Amemar mishum de kalsa abu de imach. At name mekalesat la. So Rav Asher said to Amemar, because Rami bar Chama is your mother's father. Because your grandfather praised it, so you're just going to repeat the praise, right? But it's not true. Kivad paracha Rava. Rava up here said, right? What's so great about it? You can't combine testimony about two completely different matters, and so don't just repeat repetition just because your grandfather said it. It didn't make sense then, and it doesn't make sense now. Amar Rav Safra, Amar Rabbi Abba, Amar Rav Yitzchak, Bar Shemuel, Bar Marta, Amar Rav Huna. Ve'amri le Amar Rav Huna, Amar Rav. Okay, someone said this, ultimately in the name of either Rav Huna or Rav. Rav Huna was a student of Rav, so probably it goes back to Rav anyway. Shelosha sheyashvu lekayem et hashtar. Shanai makirin chatimot yedei adim. Ve'echad eno makir. You had three judges that come and they want to verify that a document is correct, that the signatures are correct. Two of the judges recognize the signature, but one of the judges does not recognize it. So what should they do? Ad shelo chatmu, before they sign it, they can't all three sign to say, yeah, we recognize these signatures, because one of the judges does not recognize. He did not see anything yet, so he can't sign it just yet. But before they sign it, what happens is two of the judges that do recognize the signatures, they'll go around to the other side of the table and be witnesses. And they will testify in front of that one judge and say, we testify that this is the signature of A and this is the signature of B. And then the one judge on the other side will say, okay, I received your testimony. Good. I believe it. And then those two guys will now go back and sit down on the other side of the table and now be the judges again. And now all three can sign it, because the two already know it themselves, and the one now heard it from the witnesses. And me'edin befanav ve'chotem. Right, so you have to do this before they sign, but after they sign, they can't go and testify after they sign, because at the time when he signed, that one judge did not know, he didn't hear the testimony yet, and so therefore that signature would be a lie. Okay, mi katvinan. Now we ask, according to what we just said, it sounds like we write the content of the document of verification first. We write that paragraph, right? A came before me, we saw these signatures and all that, and we just don't sign it yet. But are you even allowed to write the content? V'hamara papi mishemet rava. Hay asharta de dayane de nichtav mikame de nichazu sahade achatimat yadaihu pesula. Demit hazeh keshikra. Rav Papi said in the name of Rava that this ratification document of judges, if even the body of it is written before the witnesses testify that they saw it, then it's also invalid, because it's like a lie. You can't even write the content of it. Even before you sign it, you should not even write the body of it before the thing actually happens. And so here also, he said that about another case, but this would apply here also, that they're writing something that didn't happen, and therefore as they're writing it's a lie, and that would invalidate the document. Says you're right, we'll change it. What it means is that if you have the same three judges, two of them recognize, one doesn't, so two of them will go to the other side of the table, stand up and testify, these signatures are correct. Then they'll go sit down, write the document and sign it, but the writing has to be after the testimony is given. Shema mina tilat. We can learn three things from the law that we just said. Shema mina ayadna sedayan. One of them is that a witness can also serve as a judge, like it has here. The two of them are judges and also witnesses. Ushma mina dayanin hamakirin chatimot yedei hadim enan tzrichin la'id bifnehem. We can also learn that if you have judges who themselves recognize the signature, so they don't need to hear testimony. They don't have to go and tell themselves that this is the signature. Like, for example, if all three recognized it, then they could just sit down and sign it, and no one has to present anything to them orally. ושמע מן הדיינים שאין מכירים חתימות ידי עדים, צריכים להעיד בפני כל אחד ואחד. And the third thing we can learn is that if the judges do not recognize the signatures, then the witnesses who do recognize it have to testify in front of every single one of the judges. Either they're all together, or you could do it separately, but it's not enough for them to testify in front of two, and the third one says, oh, well, if you saw it, then fine. But all three have to hear from from the witnesses. And you can see that here because you can't just rely on 2 of the judges. We have to make sure to include the third one. Okay, now Matkif la Rav Asher. Rav Asher says, not necessarily. These 3 conclusions are not all necessary. Bishlama ayed ne'aseh dayan shaminan mina. The first one I agree, because here you had a witness who became a judge. Acts as both roles. Ela dayanina makirin chatimot yeda'edim. We're going to see in a second, we're going to even reject the first one. But now Rav Asher is saying the second one, Ela dayanim makirin chatimot yeda'edim, en srichot ta'id bifnehem. If all 3 judges recognized it, then no one would have to testify orally. Is that true? Maybe they do have to. Even if all 3, they can't write that we heard testimony when they didn't hear testimony. So even if it means they themselves are going to stand up in front of each other, it's fine, they have to do that. And here the reason why they don't all do that is because it's sufficient for them to do it for one person. In other words, not every judge has to hear other people saying testimony in front of them. It's sufficient if only one of the judges hears the testimony and the other 2 judges know it on their own, as long as there was some oral section of the procedure, that's sufficient, even if only one judge heard the oral section. And that what you said, that each of the judges have to hear the testimony. No, maybe not. Maybe they don't have to. And here, how come only one does? And here, in this case, it's different. Because if they didn't testify in front of the one guy, then there would be no oral section. So in other words, once you reject the number 2, you reject number 3. The reason why they had to present to the third guy is not because every single judge has to hear testimony. Maybe not. Maybe not every judge has to hear testimony. It's enough if the judge sees that the other judges know. And here the only reason why the 2 judges testified in front of the one judge is because you need an oral section. And so to fulfill that. All right, so therefore 2 and 3 are not absolutely necessary. Okay, now even the first one we have a question on. Is it true that a witness can also be a judge? So Rabbi Abba was saying this statement that we just said, and Rav Safra challenged Rabbi Abba. It's from a Mishnah in Rosh Hashanah, Ra'u Shilosha. Behen Bedin. 3 usually we ask when we want to sanctify a new moon. We go and tell people, everybody look for the new moon. If 2 witnesses see it, they come in front of the Bet Din. So you have witnesses telling the Bet Din, we saw the moon. But let's say the witnesses didn't see it. And instead, it's the 3 judges themselves. They were sitting up on the roof, waiting for witnesses to come. And they look up at the sky and they themselves saw the new moon. So what are they going to do? They're the witnesses. How are they going to be the judges too? So here's what they should do. Yamdu shenayim v'yoshivu mechabrehem etzel hayachid v'ya'idu bifnehem. What they should do is that 2 of those 3 people who are the judges, since they are the witnesses, they should recuse themselves of being judges, get 2 colleagues to be judges in their stead. And so those 2 that were judges now are witnesses only. And they will say, we saw it, and then one of their colleagues, you only need 2 judges, you only need 2 witnesses, you only need all 3, then that one of them and 2 more colleagues that come will listen to it, and they will say, V'yomeru mekudash hachodesh mekudash, and they will declare it. It's not enough, once the witnesses say, and they're judged to be true, then the Bet Din has to make it official by saying, mekudash mekudash. She'en hayachid ne'eman al yedei atzmo. Because one individual is not enough by himself. You can't just have 3 people alone and two of them become witnesses and 1 be a judge. You need 3 people to judge. Good. That's the Mishnah. Now, if a witness can become a judge, why do you have to do all this thing? The 3 people themselves, they can, as we said before, 2 of them will go to the other side of the table, stand up, be witnesses. Well, the one judge will ask them questions, and after that, they will go back to the other side of the table and judge on the testimony that they just gave. right? You would be able to do that. So let them sit in their place, and they themselves say mikudash, mikudash. They saw it. They don't have to hear the testimony again. They don't have to hear anybody else saying it. They know it firsthand. Isn't that better? So how come here in the Mishnah Rosh Hashanah we do not allow a witness to be a judge, and you just told me that witness can be a judge? Rav Safra said, I had the same question when I heard this halacha. I asked Rabbi Yitzchak about Shema Marta. Rabbi Yitzchak also didn't know. He asked Rav Huna. Rav Huna lechia barav, and Rav Huna asked someone else. Lechia barav l'Rav, and ultimately it went all the way back to Rav, who answered the question. V'amar lehu, he said, Hanach le'adut hachodesh deoraita v'kiyum shetarot rabbanan. There's a fundamental difference. When we're sanctifying the moon, that's a deoraita law. So for a deoraita law, then we need 3 judges independent that are not also witnesses, because a judge can't be a witness. Doesn't make sense. The whole point is that the witnesses, are they true? Are they lying? You need 3 judges besides them to judge it. So for sure, that's true. That explains Mishnah Rosh Hashanah. Whereas ratifying documents, that whole law is only midrabanan, and therefore the rabbis just want to give an extra certification, extra stringency, so that people don't forge documents, like having a notary today. But since that's only drabanan, therefore we can also be lenient, and that it happens to be the same 3 people that are judges, 2 of them know the signatures, so then we allow them to be both the witnesses and the judges. Baruch Adonai Leolam. Amen ve'amen.